Good afternoon, everyone, and welcome to this webinar on training for tomorrow, with a particular focus on the regulations review consultation. My name is Simon Bullock. I'm a policy executive with the Solicitors Regulation Authority, and my co-presenter today is...
My name is Alison Pyatt. I'm a senior policy executive also with the SRA.
Great. So in terms of today's structure, what we'll be doing is running through a presentation which you should be seeing on your screens. The first section will be just a quick summary of the reasons why we are currently reviewing the training regulations. We'll be looking at the proposals one by one, with 7 in total. We'll also be asking throughout the session for any questions you may have or any input you may have into the consultation. There's a variety of ways of getting in touch with us, but today, in order to feed into the consultation proper, but today, please feel free to ask as many questions as you wish as we go through the presentation. We're aiming for about half an hour's presentation, and then we'll address those questions in the final half an hour. We'll also be publishing a list of any questions we're not able to get to, plus the answers to those questions, as well as a recording of this webinar, which we'll post online in the very near future. Okay, so yeah, we'll move on to the first section. Why are we doing this? Well, you may be aware of some recent consultations and changes we've made to the training regulations as a result of those consultations, which have happened under the banner of the Red Tape Initiative. These were really aimed at getting rid of long-standing bureaucratic requirements around training, which we felt in modern times and with our new approach to outcomes-focused regulation as an organisation as a whole, no longer added any value to our training and qualification framework for solicitors. This really builds on those consultations and regulatory changes, but it also we wanted to really prepare the ground for the training for tomorrow changes that we're also working on in parallel. Those are going to be much more fundamental changes to the training framework, potentially, whereas now we're just aiming at clearing the decks without actually making too much in the way of fundamental change to what an individual has to do in order to become qualified. So what we're not doing is things like doing away with the legal practice course with a qualifying law degree or the final period of work-based training. We're really tidying up those aspects rather than radically changing them at this point. We'll also take you through the proposals overall. I'll pass you over to Alison.
Okay, so you can see there from that slide that we've got 7 proposals, and it's all about trying to streamline the regulations and removing duplication. So we're going to talk through each proposal on an individual slide basis. So looking at proposal 1.
Okay, so proposal 1, removing complex and inflexible exemption arrangements. Now, what we currently have in the training regulations are a number of pathways which people can move through in order to gain the qualification of solicitor. The typical one is you do qualifying law degree, legal practice course, a training contract, and then you move forward to admission after having done the professional skills course. There are also routes for legal executives for people who've done non-law degrees and want to convert using the Common Professional Exam. There are also routes for magistrates, courts clerks. All of those routes have different regulations that have been introduced at different times and have had various modifications to them over the years to add some flexibility. What this has resulted in is a patchwork of routes with various restrictions, mainly based around timings and order in which these qualifications have to be achieved. What we intend to do is wipe away all of those different routes and introduce the concept of equivalent means. Now, that will allow us to look with a more meaningful eye on the outcomes that an individual has demonstrated through the various mechanisms of training, and it will basically allow us to look at what is equivalent to those to the sort of more traditional means of qualification. This will, as it currently sits in the draft consultation, and I urge you to have a look at the consultation and the draft regulations, is a fairly short regulatory arrangement around equivalent means, but this will all be backed up by fuller guidance, which we've accumulated over the years and use internally, which we'll now publish in a much clearer and more transparent way. So everybody who wishes to qualify and has done so via one of the existing routes, or has perhaps had a slightly less traditional way of demonstrating the outcomes that are relevant to solicitor qualification, can do so and can see what those criteria are, and we'll make value judgments on those criteria. What it should mean in terms of impacts is much fewer restrictive and inconsistent arrangements for the various exemptions that we currently offer. In particular, the one example that springs to mind is the ILEX route, where FILEX, or Fellowship of ILEX as it used to be, or Chartered Legal Executive Status is now, must be completed before embarking on the legal practice course. This will allow us to take a slightly more considered approach to people who haven't quite met that regulatory requirement. It will also allow us to have a recognised route for the within the training regulations, that is, for the Morgan Better applications, which are based around EU nationals who complete various parts of their training overseas in their home country, and present to us with a request to consider the equivalent against the various stages of our own solicitor training framework. So for each proposal, we'll be asking whether you agree with them. Please feel free to send us a message to that effect, and we'll also ask you for any questions you may have. And the mechanism for doing that should be in the Ask a Question section of your presentation. And again, we'll try and address at the Q&A session at the end.
Okay. I'll just look at the next proposal with you, which is to remove the requirement for a certificate of completion of the academic stage to be issued by the SRA. And at the moment, the process involves the student passing their law degree and then applying to us for recognition of the award. The provider forwards on to us the pass figures, we check the list, and then we issue certificates accordingly. The LPC provider checks for the newly qualified practitioner's qualification as part of their admission process. The newly qualified practitioner will no longer have to pay a fee and request a certificate. And so initially the purpose of our present regulation was to provide certification that a student had completed the academic stage of training. But we actually feel that this is very bureaucratic and unnecessary. And so we're proposing to remove that requirement for students to enrol, and it will be for LPC providers to ensure that their admission processes are rigorous and robust enough. What we will do is we will check admission procedures in authorisation as part of the setup process to make sure that admission processes are robust and rigorous enough to cater for that bit of the process. So again, we're interested to know what your thoughts are about that proposal, if you foresee any consequences or risks or benefits, and anything that we might not have foreseen as part of our plans.
Okay, moving on to proposal 3. This is a proposal to remove duplicated arrangements for the Common Professional Exam and the Legal Practice course. And you'll forgive me if I use one or two acronyms in this section and possibly throughout the rest of the presentation as well, so I'll probably use CPE and LPC. Over the years, some of the requirements that we set in the training regulations have been superseded by developments in regulation of higher education institutions by the Quality Assurance Agency, or the QAA. There are also some requirements that we've duplicated ourselves around the LPC. To go through those, the main ones in more detail in order, we're mainly looking at CPE exemptions. We're looking at the eligibility to commence the CPE, and we're looking at transfers between CPE providers, which are all catered for within training regulations currently. In terms of the LPC is validated by the SRA, and we use a document called the LPC Information Pack to support that validation and to act as a handbook, if you will, for LPC providers. And a lot of the requirements for successful completion of the LPC, when the clock starts ticking on time limits, for instance, and the various pass requirements and LPC outcomes, they're all contained within the LPC information pack. So the requirements that we currently have in the training regulations are really unnecessary. Going back to the CPE exemptions, CPE is, of course, an academic award, although it's usually called the GDL in that case, the Graduate Diploma in Law. And where that's the case, the provider should, in compliance with the QAA requirements, have in place procedures for accreditation of prior learning. So at the moment, the individual will come to the Law Society, what used to be the Law Society, now the SRA, of course, and say, I have 4 or more subjects on the CPE, foundation subjects, that is, which I feel I've substantively passed as a result of another similar course. We will then make a determination, looking at some internally used guidance that we have, on whether or not they are suitable for exemption. We'll give them a formal decision on a piece of paper, and they will then take that determination and final decision to the CPE provider and say, I would like to be exempted from these subjects. What we're saying as of July this year, when the new regulations are planned to come in, if they're approved, is that we'll expect the higher education institutions themselves to consider those applications rather than make that determination ourselves. There are also similar regulatory restrictions around eligibility to commence the CPE, and transfers between providers, which we feel are more than adequately covered through the QAA expectations. And we've done some mapping exercises within the SRA that gives us confidence to assert that these processes are robust enough for us to rely upon them. Okay, so again, I'd like to hear if you agree with those proposals or if you have any detailed questions.
If we look at proposal 4 now, which is around removing the requirement for training to take place under the terms of a contract specified by us. The current situation is based on the key principle of our training requirements. Intending solicitors must develop practical competence in the workplace, and for the past 30 years or so, this has been achieved through the training contract. So we specify that the trainee is to receive training at an organisation approved and regulated by us, and that the training takes place under a standard contract provided by and registered with the regulator. And we are proposing to remove that requirement. And it's important to note that we're not going to change the content or the duration of the training, but what we want to do and what we believe is that our regulatory focus should actually be looking more at the quality of the training that's provided rather than being involved in what we consider to be employment issues. And of course we would take remedial action where it was required, and I suppose really what we think is that this is a good case of over-regulation. This piece of regulation actually predates the national minimum wage legislation and also the working time regulations, which have subsequently provided trainees with more employment protections. We are the regulator, and therefore we don't see that we should be involved in any contractual employment relationship. We're not involved in any other employment relationships throughout the profession, and we don't see that we should be involved in this one. So we think that this probably is going to be of interest, and we expect to generate quite a lot of feedback from this. And so people might feel that we are removing protections from the trainee, but we don't believe so. And if you are able to have a look at our proposal, our consultation paper, you will see that we are sort of adding an option in there which says that if the profession is concerned about this issue, we've got the option of including in our regulations the requirement for all trainee contracts to include reference to regulations 11 and 12, thereby making them a contractual requirement. Therefore, if the employer doesn't adhere to these requirements, they run the risk of breaching the contract, and the trainee has potential for remedy, so through breach of contract. So again, we believe this is the right thing to do. It would help employers and individuals to move more quickly with contractual arrangements, whether it's terminating the contract or whatever that might be, because we won't be part of it. I think we just add an element of bureaucracy to it that isn't required. And you will see as part of the consultation paper that we're asking whether or not you agree with the proposal, and whether or not you believe that we should specify particular terms within the training contract to act as a safeguard, and any other risks or concerns that people might have, or whether indeed you think this is a good idea. So we welcome your thoughts.
Okay, so the fifth proposal, again, is around the final vocational stage of training, which is currently the training contract. Although, as Alison points out, if the training contract as a piece of paper goes, what we'll really be referring to in the future is a period of recognised training. Trainees will still be called trainees, a traineeship will still be called a traineeship, and there might well be a contract in place, but we, from a regulatory perspective, will no longer be referring to it as the training contract. But this one is slightly more a case of us as regulators looking at a particular requirement or requirements, thinking about really what was the reason behind them in the first place, and thinking, well, if we can't justify them from a regulatory perspective, they really have to go. Now, those two in particular are the restrictions on the number of trainees a firm may take and how many practicing certificates a training principal must have in order to hold that role. Now, at the moment, we have a ratio-based restriction on trainees, basically for every partner or partner equivalent, manager, director, or senior manager if you're working on an in-house or local government or central government basis. We basically say you can have 2 trainee solicitors. So that 2-to-1 ratio has never really been supported by any evidence that it supports the quality of training experience and, more importantly, hands-on and meaningful supervision involvement by appropriately trained and qualified staff. The second requirement that we're seeking to end is around the 1 current and 4 previous training principal practicing certificate requirements. Now, over the years of operating this requirement, we've received a number of waiver applications from individuals who, for very genuine reasons, haven't been able to have 4 continuing practicing certificates. There may have been a career break. They may have gone on maternity leave and returned to work. They may simply have been in a role where they weren't required to hold a practicing certificate and then returned to one which did. And really, it's a case of us asking ourselves, do we have any evidence to prove that that experience and solid experience as a practicing solicitor over a period of at least 4 years equates to an automatic suitability to fulfil the role of training principal? And we've had to be honest with ourselves and say there is no evidence. So that will go. Now, again, we're asking if you agree with the proposals and whether you have any particular questions around that.
So, looking at the next slide, Proposal 6, and this is looking at rephrasing the requirement for trainees to experience a breadth of legal practice. And we're proposing to remove the requirement for contentious and non-contentious experience and amend the wording of the 3 areas of the law requirement to at least 3 distinct areas of English law and practice. Currently, the regulations are intended to ensure breadth and depth in a trainee's experience, and we want them to have a rounded legal education and training at the point of admission. We have 3 requirements currently, the first being to gain experience in 3 distinct areas of law. But what we feel is missing from that is the issue of practice, because we don't feel that it reflects typical areas of modern practice. So, for example, we might say mediation or arbitration, litigation, alternative dispute resolution, and areas of employment law that may be contentious or not. And so that's why we're proposing to add the extra word practice onto that sentence. The second requirement that we specify is around gaining experience in contentious and non-contentious work. And if we look at then the third requirement, which is to meet the requirements of the SRA's practice skills standard, that includes reference to contentious or disputes-based advocacy, dispute resolution, case management, and client care. So we feel that the current regulations and requirements overlap. And so we're not saying that we don't expect that there will be a need for training in contentious and non-contentious skills. We want firms to focus on the skills that are learned through contentious and non-contentious experience, but we want trainees to have an holistic approach and a holistic experience of training, and also to enable the trainee to develop the skills needed to meet the practice skills standards. So again, we want your thoughts. We feel that the impacts of this will to alleviate the confusion and remove the need for comments around the organisation. But we'd like to know your thoughts on this, please.
Okay, the final proposal out of our 7 regulation review proposals is to remove the current requirement for student enrolment. At the moment, what happens with people who intend to qualify through the domestic route of training is that after completing the qualifying law degree or conversion course, and before commencing the legal practice course, every individual has to apply to the SRA for student enrolment. Now, this basically is a 2-part application. The first part we've dealt with under an earlier proposal, which is basically the providing us with evidence of the satisfactory completion of the academic stage. But the second part really gets to the core of why we have run student enrolment for so many years, which is an early assessment of character and suitability. So what will happen is every individual has the opportunity to disclose to us any issues which could call their honesty and integrity, suitability to become a solicitor into question. We then can consider that disclosure and reach a judgment against a clear, transparent set of criteria that we currently have within the SRA handbook, known as the suitability test. Now, currently it's a global requirement, so every single individual who wants to start a legal practice course has to make a student enrolment application, even if there are no character and suitability issues for them to disclose. But those that do disclose a character and suitability issue, it's a very small proportion of that overall group. It ranges between 2 to 3% each year. And within that 2 to 3%, an even smaller fraction actually receive from us a negative decision, which bars them from completing the legal practice course. So we've had to ask ourselves, is that global requirement a proportionate and targeted way of achieving our aims, which is to meet the legal responsibilities that the Solicitors Act puts upon us to ensure that every solicitor is of correct character and suitability? And the answer to that question, as we've asked ourselves internally, is no. What we will instead be doing is insisting that every individual who completes the legal practice course must make an active disclosure to us, or an active statement to us, confirming that there are no character and suitability issues, or that they do have a character and suitability issue and they want us to consider it before they start their period of recognised training, so before what is now starting a training contract. But we also recognise that there may be concern among people who might have a minor or a serious, for that matter, character and suitability issue, and they're concerned about committing to the very high legal practice course fees, taking another year potentially without earning, and accruing yet more debt and subsistence fees, whereas they might actually not be allowed to qualify ultimately when they reach the admission stage or the pre-training contract stage. So what we're doing is allowing any individual at any stage to make an application to us, setting out what CNS issue they might have, to allow us to make a formal determination. And at that stage, the determination will be, yes, you are eligible to commence a period of work-based training, or you are not eligible to commence a period of recognised training. Now, what this will mean to the trainees is that they won't have to make an application to us. They won't have to pay the current £80 fee. But as we are shifting the period at which we expect everyone to make that self-disclosure to us to the period before commencing training, we can still assure, as far as is possible and is practical, that when they go into the professional workplace and begin to be exposed to clients, albeit under close supervision, they will have had the opportunity for us to assess any CNS issues. In practical terms, the criteria will be identical. They'll still be assessed against the character and suitability test. I'm sorry, I've gone blank. Yes, they'll still be based on self-disclosure, and we'll have the fallback position of the admission procedure, where we can call on third-party evidence. And the one that we most frequently use, or the one that we use as a standard at the admissions test, is the disclosure of barring service standard disclosure. So we're not actually changing any of the hurdles that people have to go over. We're simply changing the stage at which that happens. So again, this could be seen as one of the more fundamental changes that we're proposing. So we'll be very interested to hear your views on that.
Okay, so the next slide just really outlines how you can get involved with all the work that we're doing, and we really do want to know your views and opinions, because that helps to inform our decisions going forward. So you can give us your views at our roadshows. We did one in London yesterday, which was very successful. We've got one in Birmingham next week, and then I think we've got one in Sheffield, is it? And where's the fourth one?
Birmingham, Sheffield, London, and Bristol, I believe.
Bristol, yes, but we've got details on our website, and the details will be there. We've got our own microsite that's been set up. You can respond to the consultation at the web address that's outlined there, and you can also participate in the online debate, and our addresses are there, or you can tweet us, whichever you prefer. So we do welcome feedback and comments, and thank you for that.
Okay, so the final slide is just to take you through when we plan to have all these changes in place. There are a number of governance steps which we need to go through in order to change a set of regulations in a large scale sense, as we're doing now, or even changing one or two words, which means it won't happen overnight. What we're aiming to do is have the board of the SRA make the new regulations in April this year. They will then be sent off to the Legal Services Board for their approval, and we're hoping to get that approval in June. We will then have the regulations come into force well in advance of the academic year 2014-2015, in July 2014. We'll also be plotting out, we mentioned earlier in the presentation, some guidance that we'll be developing, and that will really support all the decisions that we'll still be making under the regulations, and inform all of the various parties in training, that will be individuals seeking qualification or providers of training, whether they be formal education institutions or law firms, in-house practices, local and central government. They will each have clear guidance to take them through the qualification continuum, and we'll have that guidance in place before the July launch, so everyone has time to familiarise themselves with it. Okay, so I'm just looking across at the questions we're receiving, and we appear to be having a really good response. So thank you for that, with some quite involved questions. So what we're going to do now is have a quick 2 or 3 minute break. We will then come back and try and answer some of those questions. As I mentioned earlier, if there are any questions we're not able to get to, please don't be disheartened. We will be publishing a list of those questions online, along with the relevant answers to those questions. Also, once we've completed the Q&A session, we will be asking you to complete an exit survey, and also we'll be providing the CPD code for you today, where you will be able to claim an hour's worth of CPD for your records. So, as I say, we'll get to that at the end of the session. So, thank you very much for bearing with us, and we'll be back in 2 or 3 minutes. Okay, welcome back, everyone. Thank you very much for all the questions we've received, all of which are very involved and certainly prove you've been paying attention, if nothing else. So how we're going to handle this is my colleague Alison is going to read out the questions. They're all going to be anonymous. They'll be published anonymously when we publish a list of questions anyway. So Alison will read out the question and I'll attempt to answer it. So fire away.
Okay, so the first one is with regards to Proposal 7, which was about removing the requirement for student enrolment. And the question is, who will be paying for the DBS? Sorry, it's just disappeared. Who will be paying for the DBS fee? Will it be the student?
Well, currently we don't set any requirements for who should pay for the DBS. For the DBS disclosure. I mean, the application form, I believe, involves a personal payment, so the individual pays. But in terms of reimbursement from the firm, we don't set any regulatory requirements, and there's no intention for us to do so. Okay, so next question.
Yeah, the next question is about contentious experience requirements. Many city firms use the trainee litigation programme to satisfy the contentious experience requirement. Presumably, firms will be able to use their discretion going forward if they think that they can satisfy the practice skills standards in a different way. Should they check with the SRA first?
Well, yes. We're aware of the trainee litigation programme, obviously, and although the words contentious and non-contentious will be removed from the training regulations as they currently stand, when you look through the details of the practice skills standards, in order to satisfy each of those skills, people will need to have development of skills and some experience in contentious and non-contentious matters. But yes, is the short answer to the question. There will be a little more discretion for training providers, but as is currently the case, firms will still be able to get in touch with us and check whether a particular approach meets our requirements or not. As I say, the guidance that we issue. We are getting a couple of questions about this in a couple of roadshows that we've run so far. I'm sure more questions will be raised. So I think that's leading us at the moment towards covering contentious and non-contentious and what the removal of those words means in more detail within the guidance. But yes, the short answer, there will be a little more flexibility. Our guidance will cover that, and people can always pick up the phone and contact us to ask a particular question.
Okay, the next question is, will you ensure that people are aware of the requirements on character and suitability before joining the LPC?
Again, the short answer to that will be yes. at the moment, we encourage all providers of the qualifying law degree and conversion course to really hammer home to their students the fact that they have to apply for student enrolment well before commencing the legal practice course. So even though that requirement will change, what we will be doing is talking to our partners in the higher education sphere and saying, look, it's pretty vital for you to encourage your students to be aware of the changed requirements, to be aware of what, or rather of how important it is to make an early disclosure to us if they feel that there's an issue that they have that could affect their ultimate suitability, which is making them think, well, is it worth me paying upwards of £10,000 for LPC fees if I stand no chance of qualifying? We don't want to cut people adrift. We don't want to make it a gamble for people to take the step of enrolling onto the LPC and paying all that money, which is why we've designed the early application system. That will, technically speaking, that will all go through an online portal instead of currently being. Well, there is an online facility for student enrolment, but character and suitability can also be done via a hard copy form. But the new system will be totally online. It'll be very easy to set yourself up with a profile and then apply to us for a CNS assessment. So we will be stressing to course providers to say to their students, the SRA can look at this before you make that investment.
Okay, the next question is how will the SRA know how many trainee solicitors exist if training contracts are not registered? And will the SRA still be responsible for admission? If so, what will the process be at the end of the training contract?
Okay, so the first questions first. Even though we're not requiring training contracts to be registered with us, the new regulations do require the SRA to be notified where somebody begins a period of recognised training. So it all has to be contemporary. People can't come to us and suddenly say, oh, I've done 2 years training at a firm under a formal training arrangement and I want you to recognise it. It has to be, we have to be notified, at the beginning, so we can do that CNS check, importantly, and we can ensure that they are doing that training at a SRA-approved training organisation. So what will happen is, again, there will be an online system for this, which will be self-service. So the individual will log on to MySRA, or rather they will create an account on MySRA that they can subsequently log into. On that account, there will be a small number of applications they can make. One of them will be for a CNS assessment, which they'll have to do before notifying us of a period of training, and the other is notifying us of a period of training. What will subsequently happen is that the training organisation, after the individual makes the application for CNS or notifies us that there's no CNS issues, will go on to their MySRA profile. They will search for the individual trainee and they will add that trainee's record as a trainee employee to their firm's record. That will tell us who is training where and will enable us to keep an eye on how many training contracts are currently registered. How many traineeships rather than training contracts, of course. So, yes, we may not be registering them formally anymore, but we will still know how many are out there. Now, to look at the second part of the question, which is, will the SRA still be responsible for admission? Yes, we will. The process will again be mainly online. Prior to prior to reaching the end of the period of training, the application will be made available to the individual to apply for admission and basically say that their period of training has come to an end. And all the current systems, DBS disclosures, trainee sign off by the training principal will still be in place. They will be revised slightly to make them, or the sign off rather will be revised to make it a bit more meaningful and value driven. But it will be online rather than a paper form that we send out to somebody. So hopefully that's answered that question.
Okay. The next question is, will there be qualified solicitors with rights to appear in court with no experience of contentious issues?
Now, as I mentioned before, this is something that's exercised people somewhat in the two roadshows we've recently ran. I'm sure it will come up again in future. But I'll point back to the practice skills standards. It would be extraordinarily difficult, excuse me, to fulfil the requirements of the practice skills standards without exposure to both types of work. And when you look at the skills broken down, we're still requiring experience in advocacy. PSC still covers advocacy, and so it will be extremely unlikely for somebody to be able to qualify, meet those practice skills standards without the required experience, and then stand up on the first day of admission in court and act as an advocate and represent clients. There is requirements of the code that we currently have not to act outside of your competence. That reinforces that really. So we've looked at it and we don't see a risk of that happening.
Okay, the next question is, will there still be a minimum wage for training contracts?
Yes. To go further than that, I'm not just going to leave you there. The SRA board, about a year and a half ago, when we did a very detailed consultation with a extremely thorough impact assessment on whether we should continue to regulate in the sphere of trainee salaries, is still going to be enforced. And what that decision was that every trainee must be paid at least the normal rate of the national minimum wage. The requirement was agreed by the board to come in August of this year. That will come in. It is drafted in the current draft of the new 2014 training regulations. Again, I urge you to go online and have a look at those. They're annexed to the formal consultation. And it does provide for all trainees to be paid that minimum. But of course, it will still be up to each and every firm to calculate the remuneration that they will pay to their trainees.
Okay. The next question is, how will the new process recognise training done partly in the UK and partly in Europe, where those seeking to qualify are working in cross-border / dual law context? For example, graduates doing up to 6 months' work experience in a law firm dealing in English and another legal system in Europe.
Again, the short answer to this will be that issues such as this will be covered in the guidance that we'll publish. Now, there are already some training contracts that happen not just in Europe but all over the globe that we've currently registered, where training and experience of other legal jurisdictions is involved in the training that's given to an English and Welsh trainee, or a trainee in the English and Welsh legal system. We will still expect most, if not all, of that training to be substantively English and Welsh in terms of jurisdiction and in terms of law. We've got no intention to change that. But where significant portions of training, say large stages or qualifications happen overseas, we will still have the opportunity through Morgan Besser to recognise those if a formal application is made. But again, the short answer would be the guidance will cover it, and we'll still expect a significant proportion of the training to be in English and Welsh law. Okay, well, with one eye on the time, we've nearly, very nearly fulfilled our full hour. I'd like to thank you once again for listening and for participating in this webinar. We've certainly found it very valuable. The questions that we haven't been able to address now, please rest assured we will be addressing them and publishing answers to those in due course.